We hold these truths, a reverent review of the U.S. Constitution by Lawrence Patton McDonald. Chapter 7. The Illegal 14th. From the first cases they heard, justices of the Supreme Court have said too much in their majority decisions and dissenting opinions. They seem to pride themselves on their literary style. Instead of stating their decision in the case at hand and citing authorities used, they tend to philosophize and explain and thus fill the record with language which later justices expound and expand. From 1789 to 1847, however, the essay writing of justices hewed closer to the line of constitutional intent than in any later period. In citing authorities, the early justices generally used primary, authentic sources. These were, number one, comments by the framers during the Constitutional Convention when they were writing the Constitution. Second, comments made by framers of the Constitution in the Federalist Papers, which were written to explain the Constitution to the citizens before the people had approved it. And third, the Constitution itself. From 1847 to 1899, however, Chief Justices seldom, if ever, cited the Federalist Papers or records of the Constitutional Convention and often made only passing reference to the Constitution itself. Instead, they cited and expatiated on outside commentaries about social conditions, economics, and politics. While they were thus theorizing a new constitution for the nation, other momentous things were happening. During the 4-year war for Southern independence, the Civil War of 1861 to 1865, President Lincoln virtually nullified the Constitution. Lincoln assumed emergency powers to do anything he thought necessary to save the Union, raising armies without congressional authorization, closing newspapers critical of his war effort, using military force to prohibit the meeting of a state legislature and to arrest some of the legislators, jailing civilians without filing charges or allowing trial, making searches and seizures of private property without due process of law. Such autocratic actions occurred in northern states, not in rebellion against the Union. Lincoln considered them temporary suspensions of parts of the Constitution, thinking the whole would automatically restore itself when the emergency ended. Theoretically, that should happen after a war, but in actual practice it almost never does. Some war measures invariably became legislation, remaining permanently in effect. With regard to the Civil War, temporary suspension of the Constitution and lingering war laws afterwards did not ultimately damage the Constitution nearly as much as another development. That something else was a change of attitude. The war had inculcated a new concept into the minds of millions of people, even in the South, but most especially into the thinking of members of the U.S. Congress. This new attitude was based on the concept that the federal government is the place to go if you want something done. If you do not like what your state government is doing, call upon the federal government. If your state government seems indifferent or ineffective about changing conditions displeasing to you, call the federal government in to change them. That attitude, plus the hate and unreason which the war had engendered, resulted in constitutional tampering whose full and painful effects did not become apparent until the middle of the next century. Abraham Lincoln possessed none of the hate and unreason so prevalent during and after the Civil War. The noble phrase in his last inaugural, "with malice toward none," was the key to the Reconstruction policy he had already formulated. Lincoln fought the war for one purpose only: to save the Union. He never asked for a declaration of war or negotiated with the South as a separate power, because that would have been an admission that the Union was already dissolved. He never considered it so. Southern states were trying to destroy the Union by seceding. He was fighting to keep them from seceding. Since the North won, his point was established: the Southern states never did leave the Union. Therefore, according to Lincoln, as soon as they formed free governments by their own electoral processes, they were entitled to full, unrestrained constitutional representation in the United States Congress and full enjoyment of states' rights to manage their internal affairs. The rank and file of Southern soldiers and civilians were free American citizens when hostilities ended. Civilian and military leaders of the rebellion could obtain presidential amnesty and become eligible to participate in the formation and operation of their new state governments by signing oaths of allegiance to the Constitution as amended through the 13th Amendment, which abolished slavery. Such amnesty was granted automatically unless the president decided to withhold it in some particular case. After a brief period of vacillation, Andrew Johnson, who succeeded Lincoln, earnestly tried to carry out Lincoln's Reconstruction program. But Johnson did not have enough influence in the country or with Congress. Radical Republicans, as they were then called, controlled Congress. They hated the South and wanted to punish it. They were also power-hungry men who wanted to maintain their control of the entire nation, North and South. Their control of Congress was complete, but it would vanish overnight if freely elected Southerners returned to Washington and voted with the existing minority that wanted to follow Lincoln's Reconstruction policy. The radical Republicans succeeded in getting their Reconstruction programs enacted into law, and then, to make the principal features permanently binding, they proposed the 14th Amendment. 2/3 of both chambers did not vote for the resolution proposing the 14th Amendment, as must be done under the Constitution for legal passage of such a resolution. The radical Republican majority resolved that the resolution did pass and submitted it to the states for ratification. 3/4 of the states did not ratify the proposed amendment as required by the Constitution, but the radical Republican majority in Congress had the Secretary of State proclaim it ratified anyway on July 20th, 1868. By then, the radical Republicans controlled not only Congress, but also the executive branch. They had the judicial branch thoroughly intimidated, and their cohorts controlled many state governments in the North. Even if legally proposed and legally adopted, the 14th Amendment would have foredoomed freedom under constitutional law because it conflicts so sharply with the rest of the Constitution. The political intent of Sections 2, 3, and 4 of the 14th Amendment is obvious in their provisions. Anyone, rank and file as well as leaders, in any of the states of the former Southern Confederacy who had in any way participated in the Confederate cause could be prohibited from voting in any election, but the right to vote could not in any way be denied any other adult male inhabitant in the Southern states. Note that the 14th Amendment does not refer to citizens or qualified voters, but male inhabitants. This means that former Negro slaves could vote if male and 21 years old or older. So could Northern soldiers in the federal armies of occupation. So could the carpetbaggers, the federal civilian employees who were sent into Southern states during Reconstruction. And so could the adventurers, speculators, and swindlers who came in large numbers from northern states and foreign lands to seek their private fortunes in the prostrate South, protected from local hostility by the federal armies of occupation. Anyone who had ever held a job requiring him to take an oath to support the Constitution of the United States, but later had participated in the Confederate cause, could never again hold any federal or state job, civil or military, unless, quote, Congress, by a vote of 2/3 of each house, remove such disability, unquote. No public resource, federal or state, could ever be used to pay any debts or obligation of or claims against the defunct Confederacy. No public resource could ever be used to compensate any former slave owner of the loss of any slave. The political purpose of the main provisions of Sections 2, 3, and 4 of the 14th Amendment was to put the control of Southern states in the hands of persons approved by the congressional majority. It would thus tighten that majority's control of Congress by allowing only approved persons to assume the Southern membership in Congress. Very little litigation of lasting consequence resulted from such provisions in these sections of the 14th Amendment. The military saw to their enforcement without bothersome challenges getting into the courts, and the sections became functionally non-existent when Northern military rule of the South ended in 1877. It was the latter half of the first section of the 14th Amendment that foredoomed our constitutional system. Section 1 begins, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That part of Section 1 of the 14th Amendment was unnecessary. All of its provisions about national citizenship for the citizens of all states and its prohibitions against state abridgment of their privileges and immunities are fully and clearly stated in the 4th article of the original Constitution. But Section 1 of the 14th Amendment concludes with the Due Process Clause and the Equal Protection Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. What does equal protection of the laws mean? Ostensibly, it was intended as a constitutional guarantee that the law would give blacks in the South treatment equal to that given everyone else. But that guarantee had already been made. In abolishing slavery, the 13th Amendment had given blacks in the South, as elsewhere, equal status with everyone else under the Constitution. If the Equal Protection Clause was intended to go further than that, then its intent was to treat blacks unequally, differently from others. If not that, then equal protection has no intrinsic intent, but is a redundancy affirming an intent that became obvious as a part of the whole Constitution after the 13th Amendment was added. What could equal protection be interpreted to mean? Consider some possibilities. If state law protects women but not men against rape, it is not giving equal protection. If state laws impose a heavier tax on whiskey than on milk, whiskey buyers and milk buyers do not have equal protection. If a school, private or public, operating under state law admits boys but not girls, or boys under 18 but not boys over 18, or children over 7 but not children under 7, the state law tolerating such segregation and discrimination is not giving equal protection. If a state law validates a will which leaves more to one woman than to her sister, the law is not giving equal protection to the women. And how about everyone else in the state who gets nothing from the will? Ridiculous suppositions? They do postulate ridiculous litigation, but all of it is theoretically possible under the Equal Protection Clause of the 14th Amendment. Can we not depend on common sense to prevent any such theoretical twisting of what appears to be the plain meaning of a simple expression? Whose common sense? The Supreme Court's? The Due Process Clause of the 14th Amendment was copied from the Due Process Clause of the 5th Amendment, just as it had been copied into most state constitutions before the 14th Amendment was written. In fact, the due process of law expression has been copied by writers of constitutions and Bill of Rights and statutes throughout the world since it was first written into an English statute in 1355. Copying it does not change its meaning and cannot possibly have any effect on the source from which it was copied. Writers of the 14th said their reason for drafting the amendment was to guarantee the freedom of the black race in southern states where blacks had been held in slavery. The writers knew that the Constitution of southern states provided for the protection of the rights of all citizens to the full extent that providing for due process of law can protect human rights. Evidently, therefore, the writers of the 14th Amendment suspected that blacks in southern states were not being given the due process protection in legal proceedings that was provided for them in the constitutions of those states. Therefore, the only conceivable constitutional intent of the Due Process Clause in the 14th Amendment is to permit federal court review of any state court case, when properly appealed into federal court, for the limited and exclusive purpose of determining whether the state's own due process rules of procedure had been followed. The 14th Amendment did not stipulate, and nowhere in its legislative history can there be found a hint it was intended to stipulate that states must adopt federal due process rules in legal proceedings. Very soon after the 14th Amendment was proclaimed as adopted, hundreds of cases had been filed in federal courts with pleadings under the Due Process Clause. None involved blacks as such. Most of them were filed outside of the Old South and concerned business activities. It was a time of explosive industrial expansion. Some states, unwilling to wait for free market forces to solve the resultant problems, made matters worse by enacting all sorts of regulatory and special favoritism laws to attract business or control it, or regulate wages and prices, or improve working conditions. Every such state law hurt someone. The federal courts were jammed with cases complaining that state law was depriving someone of his property or his liberty without due process. The complainants did not ask for federal review to determine whether state action had been taken without affording the protection of the state's established due process procedures. That service the federal courts could legally perform if the 14th Amendment itself was legal. The complainants wanted the federal courts to assume authority under the 14th Amendment to destroy any state law the courts could be persuaded to overturn. During a period of several years, the sum of all arguments to accomplish that purpose went like this. By copying the Due Process Clause from the Fifth Amendment, the 14th Amendment had forced federal due process procedural rules upon the states. Since one clause of the Fifth Amendment had been expanded to restrain state governments as well as the federal government, the entire amendment must therefore be applied against the states. Since Fifth Amendment specifications of human rights and required procedures seemed to overlap in part with similar specifications in the First, Fourth, Sixth, Seventh, and Eighth Amendments, the 14th Amendment automatically involved all of them against the states as well. Ergo, since the 14th Amendment now applied 6 out of 10 amendments against the states, it had in effect prescribed the entire Bill of Rights against them. The federal government was thus given a vast new source of power over the states. This reasoning runs completely contrary to thoughts and purposes of the original framers, as we have seen. Their intent was to limit the rights and powers of the federal government, not to help expand them. Now, the due process concept itself no longer carried the narrow interpretation it had in English common law from whence it had come. It had evolved in the United States into great power for federal courts, not merely to review cases for procedural errors, but to make judgments on legislation itself. The 14th Amendment litigation reached the Supreme Court in 1873. The slaughterhouse cases involving butchers in New Orleans, the butchers complained that a Louisiana law had deprived them of their liberty to work and do business because it had granted one corporation the exclusive privilege of butchering cattle in New Orleans. However much the justices may have sympathized with butchers victimized by an unfair state law, a majority of them upheld the state law. In its formal opinion, the court majority observed that the sole purpose of the 14th Amendment was the freedom of the slave race, and it made sharp comments about the prevalent practice of trying to use the amendment for any other purpose. The Supreme Court decision observed that the misuse of the 14th Amendment to involve federal courts in matters affecting the general activities of people within a state was being done intentionally by persons trying to centralize in the hands of the federal government large powers hitherto exercised by the states. Fostering such purpose, the court declared, would transfer the security and protection of all civil rights to the federal government and bring within the power of Congress the entire domain of civil rights heretofore belonging exclusively to the states. Such a reinterpretation would constitute this Supreme Court a perpetual censor upon all legislation of the states, with authority to nullify such as it did not approve, all of which would be a great departure from the structure and spirit of our institutions. The language of the justices was strong and specific. They could take no other position without destroying the very fabric of our Constitution. In 1877, a Supreme Court majority used the slaughterhouse dictum in deciding Munn versus Illinois. The complaint in Munn was against a state law regulating rates that railroads could charge for intrastate transportation and warehousing of grain. The majority decision, which upheld the Illinois rate regulation law, said, "We know that this power of rate regulation may be abused, but for protection against abuses by legislatures of the people must resort to the polls, not to the courts. Courts," the majority opinion observed, "do not substitute their social and economics beliefs for the judgment of legislative bodies." Corporation lawyers and others who might be considered spokesmen for big business in the 1870s had been silent about the slaughterhouse decision of 1873, which upheld a Louisiana law granting an important monopoly in New Orleans to a big business. Many big businesses were then enjoying state-granted monopolies. But the Munn decision in 1877 was a different matter. It upheld a state law that was hurting big businesses, and spokesmen for big business were outraged. They called the court's Munn decision barbarous. The Munn decision of 1877 was the main, if not only, motivation for formation of the American Bar Association in 1878. The chief purpose of the ABA, when formed, was to lead a fight against such state regulations of business as the Supreme Court had upheld in Munn. It was commendable of the ABA to make the fight, but it should have done so at the state level. The federal government should have been kept out of the fight. The Supreme Court rulings in 1873 and 1877, which refused to meddle with state laws, were by a slim majority. After 1878, pressures mounted. The court's attitude gradually changed, and case by case, the court accepted one or the other of the strange arguments that could convert the federal government into an absolute dictatorship over all the cities, counties, states, and people of the United States. Under the new interpretation, the Supreme Court would have the last say about what the dictatorship could do. One court case along this road of judicial revolution is worthy of note, primarily because of a minority opinion written by one of the justices. In Lochner v. New York in 1905, the Supreme Court accepted the theories that the 14th Amendment had taken over a large part of the Bill of Rights and that due process had new meaning, which gave the court powers theretofore untapped. In Lochner, the court overturned a New York state law regulating working hours in bakeries. In doing so, it passed judgment not only on the state law, but on the social and economic conditions behind the law. The court was divided. The majority of justices thought working conditions in bakeries were not bad enough to justify the state in setting limits on working hours. Dissenting in Lochner, John Marshall Harlan, grandfather of a later justice with the same name, wrote these prophetic words: "No evils arising from state legislation could be more far-reaching than those that might come to our system of government if the judiciary, abandoning the sphere assigned to it by the fundamental law, should enter the domain of legislation, and upon grounds merely of justice or reason or wisdom annul statutes that had received the sanction of the people's representatives. The public interest imperatively demands that the legislative enactments should be recognized and enforced by the courts as embodying the will of the people, unless they are plainly and palpably beyond all question in violation of the fundamental law of Constitution."